Judge, with all due respect, I ask you to recuse yourself from this trial. What's that about? And will the judge go ahead and do it? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney, and it's a beautiful day today here in Great Neck, and I've got the birds chirping, the dog is barking, and I wanted to give you this great information. So now, here's the scenario. We have a medical malpractice case where you have brought a lawsuit against your doctor claiming that he was careless and violated the basic standards of medical care, causing you significant harm and injury. The defense turns around and says, no, I did nothing wrong. Why did you sue me? He says, listen, if I did something wrong, guess what? So did you, Mr. Patient. Then he turns around and says, listen, whatever I did didn't cause or contribute to your injuries. And then he turns around and says, you know what? Even if I did something that caused you harm and injury, your injuries really are not as bad as you claim them to be. So they also tell us, listen, because we don't believe we should be involved in this case, we are never going to settle this case. We're never going to negotiate. Okay, that's fine. So now, 2 or 3 years down the road, when your case comes up for trial, because that's how long these malpractice cases take to get to trial, now when your case finally comes up for trial, we go ahead and pick a jury, and then the trial assignment judge randomly assigns us to a trial judge, an available trial judge. And before we actually start the trial judge wants to meet with us, meets with the attorneys in his private chambers. And why does he do that? For a couple of reasons. Number one, he knows nothing about your case. So he wants to know from the attorneys, what's this case about? Now, that doesn't mean he wants a half-an-hour recitation of all the details about everything involved in the case. He wants a 2-minute summary. Counselors, what's this case about? Judge, it's a failure to diagnose lung cancer resulting in death of this 40-year-old patient. Okay, now he knows enough about what this case involves. And then he'll get into logistics about scheduling and witnesses and legal rulings that he may have to make immediately before trial. So now during this conference that takes place before we actually begin and start the trial, I turn to the judge and say, Your Honor, with all due respect, I ask that you recuse yourself and have the trial assignment judge assign us to a different judge. Now, the first thing the judge is going to ask me is, why, counselor? Why would you want me to recuse myself? Judge, I understand that you are very good friends with the defense lawyer. And he says, yes, that's true. And I say, Judge, I understand that you also socialize with the defense lawyer. Is that right? Yes, that is true. Well, that's just one of the reasons, 2 of the reasons why I ask you to recuse yourself. And the judge turns to me and says, why, do you think I can't be fair even though I'm friendly with the defense lawyer? Even though we are friends outside of the court system? I said, Judge, it gives the appearance of impropriety. That's the appearance that it gives, whether or not that's true or not. And the judge turns to me and says, your request is denied, counselor. And then I say, Judge, I also understand that you serve on various Bar Association committees with the defense lawyer here in this case. And he says, yes, that's true. And I also understand you are responsible together with the defense lawyer for being part of the finance committee to finance certain campaigns, political campaigns, of various judges in New York State. Isn't that true? He says, yes, that is. Judge, don't you think that also raises the appearance of impropriety? In all likelihood, the judge is going to get offended at me because I'm now claiming this judge can't be fair and impartial. But here's something else you should know. In most of these medical malpractice cases that go to trial, they are almost always involving a jury. And what does that mean? It means that we select 6 members of the community to decide whether you are more likely right than wrong in order to justify a verdict in your favor. The judge, in that instance where there is a jury to evaluate the case, the jury decides what are the facts, who's telling the truth, who is more credible, who is less credible. And now the jury has to ultimately decide whether or not your doctor violated the basic standards of medical care, and if so, whether those violations were a cause of your injuries. And if so, how much money you are to receive as compensation. In that instance where we have a jury to decide those things, the jury is known as the finders of fact. They don't wear any black robes, but they are the ones to make decisions about who's entitled to a verdict in their favor. The judge doesn't participate in that. The judge makes rulings of law. The judge rules on what questions can be asked. The judge rules on what evidence comes in. The judge sets scheduling. The judge decides what witnesses will be allowed to testify. So the judge controls the entire court proceeding. But the judge does not play a part in deciding who's more likely right than wrong. The judge gives the jury legal instructions at the end of the case, the law as it applies in this particular case that the jury must follow. But now, here's something else that's interesting. At the end of the case, after the jury comes back with the verdict, the judge, as a matter of law, can decide to throw that verdict out if it is inconsistent with the weight of the evidence. On the other hand, the judge can agree that this verdict should stand. And now the jury has spoken. So now the moment I ask the judge to recuse himself, to take him off of this case, because it appears that he's too close in some fashion to the defense lawyer, now he's going to get all offended, because he's going to say, hey, I can be fair and impartial. My relationship with the defense lawyer has nothing to do with my ability to make legal rulings in this case. And you know what? That might be true, but then again, it might not. Now, the judge may bend over backwards to lean in my favor to show everybody that he's not favoring the defense. That's a possibility. On the other hand, he may actually rule in favor repeatedly for the defense attorney. That's a possibility. But what does it take to get a judge to excuse himself from a particular trial? If we can show that there's actual bias, if there's an inherent relationship that clearly makes it obvious to everybody who hears about it that there's something that shouldn't be going on here, in that instance, the judge should excuse himself, and now the trial assignment judge will assign us to a different judge. Simply by asking the judge to excuse himself may put me in bad standing with the judge. Why? Because now I'm accusing him of not being able to be fair and impartial. So why do I share this great information with you? I share it with you because this comes up occasionally. And now, if you hear about it from your attorney, that he's tried to get the judge recused from your particular case, now you may have an insight into what really goes on when an attorney tries to do that. You know, I understand you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you have not yet started a lawsuit, but you are thinking about bringing a case and still have questions, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.